Welcome to today's immigration tidbit, although this is the longer version of the tidbit. So I get a lot of questions about fiancés, and one of the most common one are, the U.S. citizen wants to travel to the country that the fiancé is in, and they want to just bring them back and maybe apply for a fiancé visa, in the U.S. or apply for a fiancé visa and then have them apply for a visitor visa to come while it's pending, because it is taking now 9 months to a year once it's submitted for the fiancé visa to go through. And for those people, those lovebirds that are just starting out, 9 months to a year can seem like forever. So, a few things. The B2 visitor visa is meant for that, it's meant to visit. And in order to get an approved visitor visa, you have to have, not maybe, you must have non immigrant intent. Now, what is non immigrant intent? Okay. Non immigrant intent is where you do not intend to become a lawful permanent resident. You only intend to become a visitor and then leave. Now, you have to ask yourself, how can you prove, if you come on a visitor visa and you want to apply for a fiancé visa, that you can have non immigrant intent? And the answer is you can't. It's not possible. You fully intend to become a lawful permanent resident. Okay? So even if you successfully convince the officer that you really are just intending to visit before the fiancé visa goes through, it will never be approved, because you simply cannot prove non immigrant intent, which is a requisite requirement for the B2 to be approved. So once people understand that the B2 cannot be issued once someone is on a fiancé visa or going to apply for a fiancé visa, they start trying to go around the law. They'll say things to me like, okay, what if my fiancé doesn't tell them that they're going to apply for a fiancé visa, and they come into the US without informing them that they have a fiancé? Well, there is some serious risk to that. It's not like immigration hasn't been around a long time. It's not like they do not know the games that you're trying to play. And by doing that, once your fiance visa, let's just say, they get approved because they misrepresented the facts of who was here and what they really intended to do. So let's assume they come here to the US under those circumstances. What likely will happen is that later, when they apply for the fiancé visa, and even later when they apply for the green card, the officer will see that in fact when they entered the US, they didn't intend to visit, but they intended to apply for the fiancé visa, thereby slapping the charge of misrepresentation and fraud on the foreign national, your fiancé. And now, in order to get here to the US, not only do you need to prove that you have all the requirements for the fiancé visa, you need to file a completely separate and independent waiver to show hardship to your US citizen spouse and all kinds of other stuff in order to even get to the point where the fiancé visa is adjudicated. So you essentially have made your case much, much more difficult by committing misrepresentation and fraud, because you thought that you were smarter than the immigration officials who have been doing this for the last 100 years. Maybe not the one that's interviewing you, but certainly they have a playbook on what people do. Um, the next thing is that people don't apply for the fiancé visa once they are in the US. Okay? If a person comes here to the US, you just don't apply for a fiancé visa. You would ultimately get married and apply for adjustment of status, where you don't have to leave, or if you do leave, it will be with advanced parole. So, given that, the best way to go about this is to just apply for the fiance visa, and if you can't stay apart, then you, the US citizen, go and visit your fiance or go to another country closer to the US. It doesn't have to be, your fiance doesn't have to stay in his or her home country. If they are able to travel, for example, to Canada or Mexico, and without a visa, or where they can get a visa very easily, you can go visit them there. Do not try to bypass the US immigration system by thinking that you're smarter than all of the officers that have been doing this and that have a written playbook on what you guys are going to try to do. There's a reason that officers do not believe anything that you tell them, that they think everything is a lie, because a lot of people do lie, and you have to prove them differently. So with the fiancé visa, that by itself is hard enough to get approved. Okay, you have to prove the bona fides of the marriage, the pending marriage, that your fiancé does not want to marry you just to get the green card. You have to prove that the relationship is legitimate, that there are no grounds of inadmissibility. And one of them was what I just told you, a possible new fraud and misrepresentation ground. You have to look for red flags. Okay, if you've only known each other for 6 months or 4 months and now you want to get married, uh, the first thing that will jump out at the immigration official is that your fiance wants you only to get the green card. So you're going to have to properly prove what you need to prove to show that that's not the case. There are times where you haven't even seen your fiance and you want to try to apply for a fiance visa based on that. And in order to do that, you need a waiver of the personal meeting requirement. I've had people tell me, well, they can't get off work, it's too expensive for an airline flight. Immigration doesn't care about that. If you're going to get a waiver granted, you're going to need a much better reason than that, such as a disability, medical reason. Of course, COVID was a very good reason. They wouldn't even let you on the plane to go visit your fiance, and that was through government regulations of both countries. So those are the reasons. Okay, but getting back to the primary purpose of this video, to show how the B2 visitor visa and the K1 fiancé visa do not mix and match, you have to decide what you want to do. If you want to visit, go ahead and try to visit. But just note that many countries, even if you say you have a US citizen boyfriend or girlfriend in the US, that by itself will get the visitor visa denied, let alone if you're going to apply for a fiancé visa. So, I hope that I've clarified some of the issues. You have to be patient in immigration law. Don't try to bypass it. Don't try to think you're smarter by doing things that you think they'll never know what you're doing. I mean, honestly, when people tell me this, they don't even have to finish the sentence, and I know exactly what they're going to try to do. I've had people, I tell them the law, I tell them what, in my opinion, is the best thing to do, and in their minds, they completely ignore me. They want only to be together no matter what. They don't understand the consequences. They don't want to hear the consequences. And then they go forward and they do it. And, a year later, one of them is in my office wondering why they're not together yet and why they have to file a waiver. So be smart, file it properly, and then eventually you'll be together. Okay?